So it is with particular happiness that I introduce Allison to introduce our star-studded panel on false confessions. I think this is going to be a fascinating conversation, and so appreciative of all your work over the past year. Thanks.
Here, I'm going to be very brief. I'm really excited. Can people hear me? Yep. Thanks. I've been thrilled to be at the Quattrone Center this past year. I'm very sad that it's ending soon, but what a great way to end. This is a panel that I'm really excited about. We are going to be talking about the second scientific review paper on police-induced interrogations and confessions. The first one was published in 2010. We can't believe it's been about 13 years already. And we can't believe how very much more science has been produced on police-induced confessions. And so we're really excited to present it to you. We're only 4 of the 7 authors on the second draft here today, but I'll introduce Saul Kassin, our fearless leader, on both version 1.0 and 2.0. He's a distinguished professor of psychology at John Jay College of Criminal Justice, and he absolutely, without question, pioneered the scientific study of false confession. And I'm very pleased that you were able to join us today. He has a wonderful book, came out last year, 2022. It's called Duped: Why Innocent People Confess and Why We Believe Their Confessions. We also have Professor Kyle Scherr with us today. He's a professor of psychology at Central Michigan University, an associate editor at Law and Human Behavior, and one of the world's leading experts on interrogations and confessions, biases in forensic science, and wrongful convictions more generally. And to my right, we have Dr. Hayley Cleary, a professor of criminal justice and public policy at Virginia Commonwealth University. She too is a leading expert on interrogations and confessions, particularly for juveniles and issues relating to trauma, which is very much often the case when we're talking about false confessions, as people are accused of murdering their loved ones and such. And I'm thrilled to have this session, and I'll turn it over to Saul.
Thank you. It's a pleasure to be here. My name is Saul Kassin, and we are going to talk about false confessions in a whole lot less time than we should have. There's just a lot to say. I want to talk about, and I want to do this in trying to be in an efficient way. The original white paper that Allison referred to was published in 2010. It was a scholarly piece that reviewed what we knew from basic psychology and what we knew from early research on police interrogations and confessions. This has become an important paper. In fact, the American Psychological Association has used it as a template for now 10 amicus briefs and 2 resolutions with regard to the interrogation of criminal suspects. So much has happened. There was a clamoring for an update, a white paper 2.0, a scientific review paper 2.0. And this is what's coming, and I anticipate probably a year from now. But you can see we have 7 authors. We have assembled a team of 7 authors. 4 of us are here today, and this is the first time we're appearing together in that context. So I want to say a little bit. I'm not going to say too much on my end. I'm going to mostly preview what everyone else has to say. But let me start with the numbers. It's the first question you ever get as an expert, as a consultant. How often does this happen, false confessions? And the underlying assumption has always been it's an event that seldom occurs. Once in a blue moon is a phrase I've encountered thousands of times in my career. That's not it. When you take a look at the pages of history, in the United States and everywhere else in the world, in the criminal justice systems, military, work and school settings, there's nothing new about false confessions. I know it feels to a lot of people like this post-DNA world phenomenon. It is not. History takes us way back, and in fact, the first wrongful convictions ever discovered in the United States back in 1819 came as a result of 2 false confessions to a murder in which the alleged victim showed up alive. If you look now at what we do know about numbers, the Innocence Project, which has cataloged DNA exonerations up until 2020, and they're starting to reshape their database, but 29% of the DNA exonerations in their files involved false confessions, either by the defendant or somebody else who implicated the defendant. And that number is, interestingly, when you look at a subsample at the Innocence Project of homicide cases, that number goes up. It doubles to 61%. Second database, the National Registry of Exonerations, founded 20 years after the Innocence Project, they now have archived 3,300 or more wrongful convictions, of which 12% of the suspects themselves had confessed. And again, when you look at the subsample of homicides, that number doubles. Now, all of that makes the doubling in the homicide cases may seem counterintuitive. One would think as the severity of the crime and the stakes of the sentencing went up, it would be harder to get people to confess. But homicide detectives are a different breed. Those are a different breed of cases. And that's why no matter which database you look at, the ever-presence of confessions is particularly true in homicide cases, the ones you might least likely expect. Over the years, research has documented 3 types of false confessions and the kinds of risk factors that we should watch for. It is important to know, and that's pretty much what we covered in Scientific Review Paper 1.0 and part of what we will cover again in 2.0. It's important to realize that the cases we know about are just the tip of the iceberg. I've worked on cases in which an individual had confessed, and prior to being charged, the actual perpetrator was found, and quietly the charges were dismissed. And confidentiality agreements sometimes were made. Those cases never make into the books. And then there are other cases in which the individual who confessed later pleads guilty, and their case is never subsequently scrutinized. Then there are other cases in which, and I could talk about a number of these interesting cases, in which individuals confessed and they served their time, and only later were their cases scrutinized and they didn't bother to go back and get their convictions overturned. And then finally, many false confessors remain in prison. There are, in my head, a number of I have a haunting list of cases that still need to be resolved. Analysis of DNA exoneration cases, and this is important, and Allison is a co-author on this paper. I understand the law enforcement perspective that we close cases on confessions whenever we can, that when you hamper us, when you handicap us from closing a case, that's not good for public safety. Well, think again. Because what we know from the DNA exoneration cases is, in this study by Norris and Allison and others, when those cases are analyzed and the DNA not only has excluded the wrongfully convicted person, but then identifies the perpetrator, and you go back and trace the record of that perpetrator since they were not captured at first, they go on to commit hundreds of additional violent and sexual offenses. Closing a case on an innocent person is not good for public safety. And so I would argue forcefully that from a public safety perspective, false confessions and the consequences we're going to talk about are to be avoided. So let me start first by talking about the causes of, you have no idea, by the way, how hard this is to condense all causes, consequences, remedies into 30 minutes. False confessions, causes. Psychologists have, over the years, and confessions researchers have looked at 3 categories of causes. 1, certain types of suspects are more vulnerable than others. Hayley, Cleary will talk about youth as a vulnerability factor. 2, the processes of interrogation are often risk factors. That is, certain interrogation tactics increase the likelihood that even innocent people would confess. And that's what I want to spend a little bit of time talking about. And then 3rd, there is this concept called the phenomenology of innocence that is in some ways mind-numbing, almost too much so to spend any time on today. But the idea here is that Innocent people, they waive their rights. They waive all of their rights. They don't understand the peril. Sometimes they even confess thinking that everything's going to work itself out because they didn't do anything wrong. When I ask innocent people, for those of you who think Miranda is the great safeguard, when I ask innocent people, why didn't you ask for a lawyer? Why didn't you remain silent? Well, I didn't need a lawyer, they would say to me. I didn't do anything wrong. And so the phenomenology, the subjective state of innocence, has become a risk factor. Here's what I want to focus on. I want to focus on the practices of interrogation. And again, I'll do this in a very brief amount of time. A couple of years ago, I wrote an article for the New York Times. It's time for police to stop lying about evidence. Most Americans don't know this, that police are allowed to fabricate evidence. When they confront you about your guilt, and they do so in a level of certainty, and they present whatever evidence they have, they can also present evidence they don't really have. Most Americans don't know this. So the average suspect, often an adolescent, is sitting there hearing that their DNA was found on the victim, or that their fingerprints were found on the weapon, or that surveillance footage shows them committing the crime, or that the polygraph test they asked to take and passed, they actually had failed. Or these days, I'm seeing more and more cases of, we have records of your cell phone pinging at the location of the crime scene. People don't know this. And what happens in these cases, and I will simply in one felt swoop say, there is a 100 plus years of basic psychology saying that when you misinform people about reality, you can change their perceptions, their visual judgments, their beliefs, their emotional states, their motivations, their autobiographical memories for things they saw and did. There is no doubt, no dispute as to the power of that tactic. And yet it remains. And there is no limit to the number of lies police can tell to a suspect, to the magnitude of those lies, and nor is there a limit to who you can tell the lies to. Importantly, right now, there are a number of developments in state legislatures that are warming my heart. Starting in 2021, 4 states have banned police, that have passed laws that ban police from lying to juveniles. In 2022, another 3 states. Right now, there are 4 or 5 additional states considering similar laws. That is high time. And it isn't just the academic community that's clamoring for this. I recently wrote a Time magazine article accompanied by 7 law enforcement gurus. In fact, I'm looking at James Trainum, one of them, retired detective from DC Police, yes, who wrote a phenomenal book about false confessions a few years ago, following an article he wrote in Police Chief magazine, with the title of which is something like, "Don't Tell Me False Confessions Don't Happen." I took one myself. You could see Jim Trainum and 6 others also wrote important commentaries about how lying about evidence puts innocent people at risk. It does more than that. It puts innocent people at risk. It's not necessary to solve the crime. It's not necessary to get the confession, and you lose the public's trust. Good luck getting the public's cooperation in solving crimes and investigation when they don't believe that you're being truthful. And so this isn't just an academics versus practitioners conflict. A lot of insightful people are on board. And I should add that as far as this lying about evidence, the U.S. is one of the very few countries that permits it. Very few countries that permits it. What I really want to focus on in light of the audience, if this were an audience of police officers and detectives, I would focus on the things you can do to prevent false confessions from happening. But that's not in your bailiwick. And so what I'm going to do is focus instead on the things you can do as the person who evaluates a confession to know what it is that you're looking at. I want to talk about the consequences of confession. And why is it that confessions are so devastating? When I first started to do research in this area, I took some comfort in the belief that the fact that innocent people might be induced to confess, okay, that's a problem, but that problem should solve itself. There are so many layers of safety nets within the system that hopefully in the end it doesn't make a difference. I was wrong. And let me just start with the first problem with confession evidence. As soon as confessions are released, case closed, enough said. Boom, as my granddaughter would say, boom. Just look up in the left, the top left, at Hugh Burton in Bronx County, New York. Hugh, without getting into the details, 16 years old, called 911. His mother was stabbed and killed and left in the house. He finds her. 3 days later of interrogations, he gives a statement on videotape, 900 words uninterrupted, details and all, in which he confesses to killing his mother. Without getting into the details again, 1.5 weeks later, his mother's car had been stolen, her keys were missing, all of that. He didn't have any of that. 1.5 weeks later, somebody north of the Bronx is stopped running a red light. The police stop the car. They run the plates. It's the mother's stolen car. Now they run a check on the identity of the driver. He has a long record of felonies, including violent assaults on women. And then they come to find out that his girlfriend had just moved into the Burton's family's home. They would do a reset. They did not. Instead, they went up, interviewed him, and in exchange for filing no charges, he implicated Hugh Burton. Became part of the prosecution. Man not. Same thing happened. 2 weeks after she confessed the narrative, 2 weeks after she confessed, the guy, DNA was the violence. There's nothing. Case closed. Trying to think. Confession is case closed. Medical. Judge. Central Park judge. 1889 based on confessions. 2002 they were exiled. The deal. One judge at the time in 1989. And the juries decided we've got confessions, we've got exculpatory, made the confessions outright. You see that often? We've shown it in research. Why is it? Well, the first problem with humanity is our common sense. We have a logical attributional theory that people don't do things against their own self-interest, and that's a good rule of thumb. In circumstances, they do just that. But it's more than that. It's more than just common sense. And this is the parts I want to emphasize. There is the internal corroboration, as I call it. False confessions contain proof of guilty knowledge. So when you look at, and this fully crediting Brandon Garrett, law professor at Duke University, Garrett published a couple of papers in which he analyzed proven false confessions from the case files of the Innocence Project. And he compared them to the evidence in those cases. And what he discovered is that 94% of false confessions by innocent people, no dispute as to their actual innocence, 94% of those cases contain facts. You're not seeing a recording of the interrogation. You don't know how he knows those things. But that's the first problem. 94% of false confessions contain internal corroboration in the form of proof of guilty knowledge. And if you don't believe Garrett's data, again, I'll point to my friend Jim Trainum, detective, retired detective from DC, who wrote an article about taking a false confession. And when he realized that the person who had confessed was being exonerated, he went back and pulled the tape off the shelf and realized, to his surprise, that the facts that she got and placed into her final confession originated with him. We've done lab studies now that show that happens inadvertently. It simply happens as a function of two people having a conversation where we communicate information, and therefore it's very common for detectives to inadvertently communicate information about the crime facts, which then find their way into the final confession. Second, it turns out that false confessions also contain other cues of credibility, not just details. They contain chronology. They contain statement. This is what I did. This is how I did it. This is when I did it. This is who I was with. This is what the scene looked like. I'm so sorry. I wouldn't do it again. There are apologies and expressions of remorse. Corey Wise of the Central Park Five, he said, "This was my first rape and it's going to be my last. I'm never going to do this again." He expressed remorse. That is the sound of a false confession. Often they contain demonstrations, physical demonstrations, diagrams. In shaken baby cases, sometimes you see a demonstration with a doll. This is how I threw the child to the ground. And so these are cues that appear in false confessions. To give you an example, and I'm looking at, I put one up from the state of Pennsylvania, case involving Barry Loftman. In case you don't realize just how precise and vivid these details are, I'm gonna read from Barry Loftman. The victim was found lying on her bed.
Saul, I'm sorry, I don't want to interrupt you, but you need to on the microphone for the people streaming.
Oh, okay, sorry. Yeah, I can turn. Among the details that he said, the victim would be lying on her bed. She'd be face up on a pile of clothes. She'd be injured from a blow to her head. Her arms were bruised. And then he goes on and on and on. There'd be no fingerprints in the bottle, 4 or 5 Marlboro cigarettes that I smoked in the house. I put one on a chair near her bed. The front window was open. Come on. And all of those were spot on in relation to the crime scene. Now, there's no way that a judge or a jury who hasn't seen the process by which that statement is taken could do anything but believe that this person has guilty knowledge and is therefore the criminal. And I'm going to pass that. I want to point, and I've got a couple of asterisks, what I'm not going to talk about with regard to consequences, because others will, is confessions corrupt lay witnesses and other evidence. It's important to realize in cases like Amanda Knox and so many others that by the time the confessor goes to trial, they're not going to trial just on the basis of the confession. They're going to the trial on the basis of all sorts of other additional evidence corrupted by that confession. Without putting up a slide, I can recite the case of Anthony Wright in this neighborhood. Anthony Wright, by the time he went to trial, he was tried not only on the basis of his confession, he was tried on the basis of 2 eyewitnesses who coerced, we turn out to find out, were coerced to identify him, 2 informants who said they overheard him confess, bloodstained clothing that was in fact not really found in his house after all. All of that made its appearance in his original trial. And so he was convicted not just on the basis of the confession, but the evidence the confession corrupted. And then finally, last but not least, confessions are also often, again, quote unquote, corroborated by guilty pleas. If you look at the data, once again, the Innocence Project and National Registry data show that if you have confessed, if that's one of the contributing factors in a wrongful conviction, you are more likely then to have then pled guilty as well. I'm going to pass up these because I know Kyle, you're going to talk about the ways in which confessions corrupt. The remedies, I just want to close with two things, and then my 3 blanks are for my 3 additional speakers. First, 31 or 2 states now require the recording of interrogations from start to finish. That's a no-brainer. The fact that the state of Pennsylvania doesn't do that is a mystery to me. I don't know how a judge can determine the voluntariness of a confession without watching the process. I don't know how a jury can determine the credibility and reliability of a confession without watching the process and knowing where the statement finally came from. There's been a lot of opposition over the years. There's, again, 32 states now that require the recording of interrogations. There are, for my taste, too many loopholes and exceptions in those laws. So, for example, I've heard some departments say, well, you know, we're ready to record, but the suspect wouldn't go on camera. I'm sorry, I've done that research. I've done that in field studies where we inform or not inform real suspects in real cases that they're being recorded, and we never saw a single person object. In the 1970s, where confessions, not interrogations, were recorded for the first time, Bronx DA Mario Merola was quoted in the New York Times saying, the beauty is, every time we have a confession on tape, we get a conviction, and nobody refuses to go on tape. That was in the 1970s and 1980s. The idea that I hear, the objection, that suspects won't talk to us on camera, I'm sorry, that's just not true. And we have the data to show it. Additional issues, the suspect wasn't in custody. We had equipment malfunction, at which point I like to theatrically pull out my cell phone because I can't remember the one or any time that my cell phone camera refused to operate. And New York State, for example, has this as an exception. So the law is you must record interrogations from start to finish, or else the confession taken is not admissible, unless, and then the exceptions begin. And one of the New York exceptions is, I kid you not, inadvertence. Inadvertence. It's not that hard. It's in the interest, this transparency is in the interest of justice. It enables prosecutors to evaluate the confession they are handed. It enables judges to do the same at a suppression hearing. It enables juries to do it at trial. It's necessary. There is no way to evaluate a confession on the basis of secondhand information provided by, on the one hand, the witnesses from the law enforcement side and the defendant, all presenting very, very different points of view as to what transpired. Second, we need to reform interrogation practices. And that's where Detective Trainum comes in. It's where so many others in the law enforcement business come in. There are now alternatives. There are alternatives to the confrontational process by which we do 2 things. Because right now, the reason suspects who are innocent confess is they are overwhelmed by the presentation of evidence that makes it look like with or without them, with or without their cooperation, they will be convicted, tried, prosecuted, and convicted. And why? Because we have this mountain of evidence, even if that evidence is false. 2, they often get confused by that evidence and disoriented by it. There are cases in which people, 5 minutes? Okay. There are cases in which innocent people not only agree to confess as an act of compliance, they come to believe in their own guilt. They get confused and disoriented. And they, as we call it, internalize the belief in their own guilt. These cases are crazy. The first couple of times I saw them, I didn't know what I was looking at. But what happens in these cases is you have a suspect who may be youthful, maybe was being sleep deprived, maybe has intellectual issues, and that suspect is lied to over and over about evidence so that they come to believe in their own guilt. And what happens in these cases, there's a predictable pattern. Wait a second, you're saying you have my fingerprints on the weapon, but I wasn't there. Well, you know, sometimes people don't remember everything they do. And so you get kids like Peter Riley in 1973, the poster child for my discovery about this type of false confession, who says, I don't know, this machine of yours, the polygraph, they lied to him about the polygraph, is starting to give me doubts. It looks like I did it. I guess I did it. Maybe I did it. You get this hybrid, not the language of memory, but the language of inference. It looks like I must have done this, but how could that happen? at which point the conversation turns to memory and consciousness and the possibility of a blackout, or that you did this in your sleep, or there's a possibility that there's a split personality. Michael Crow was told, a 14-year-old in San Diego, there's a good Michael and a bad Michael, and the good Michael was asleep while the bad Michael killed his sister. The point is, how can that be allowable? The U.S. Supreme Court last looked at the issue of lying about evidence in 1969 in Fraser v. Cupp. They have not readdressed the issue since. There have been hundreds of experiments, hundreds of studies, hundreds of wrongful convictions in which that tactic was used to get innocents to confess. How can the courts not revisit that issue? And so state legislatures are doing it for them. Part of that this last point, those are the micro changes. We can take interrogation practices as they exist today, the Reed technique, for example, and we can micromanage them to say, okay, you're not permitted to lie about evidence. You're not allowed to suggest minimization themes that imply leniency, that communicate leniency by pragmatic implication. Or we can go macro, and we can take a look at some of the bigger developments that started in England and are working their way through the world, in which the confrontational approach to interrogation is wholesale adjusted and replaced by investigative interviewing. And there's no time to get into that, but in England and now elsewhere, and now working its way through many of the law enforcement gurus whose names I put up on the commentary, there is now an alternative to using these confrontational approaches that would reduce the likelihood of false confessions. And so that's where I want to end. Coming up next, Hayley Cleary to talk about developmental considerations as a risk factor, Allison Redlich on confessions and guilty pleas, and Kyle Scherr on the corruptive effects of confession. I thank you.
So I have the unenviable task of following Dr. Saul Kassin. It's a difficult but honorable position to be in. So my name is Hayley Cleary, and I am a developmental psychologist by training, and I specialize in adolescent development, particularly how adolescents think and behave in legal context, like police interrogation. And so what I'm going to talk about today is to carve out just a tiny, tiny piece of the scientific review paper as it pertains to youthfulness as a vulnerability for false confessions. So essentially, as Saul alluded to, summing up your life's work in, I get 15 minutes, I think. So we'll see how I do. Cut me off, Allison, if I start rambling. So when I'm talking with attorneys in particular, well, really any legal actor audience, I begin with asking the question, what is adolescence? Because the question that I often get in response to that question is, well, isn't it the same thing as juvenile? It absolutely is not the same thing as juvenile. So adolescence is a very critically important developmental period. It is a unique period. It is developmentally, biologically, neurologically, socially, distinct from both childhood and adulthood. And this is a period of life where young people's thinking and behavior are fundamentally different from that of adults in important ways, in knowable ways, and in ways that have serious implications for those youth and their families when they interact with the criminal justice system. So from a developmental perspective, right, this is where sort of psychologists and attorneys we don't speak the same language sometimes. So from a developmental perspective, adolescence is a spectrum. You don't obviously become an adult overnight. You don't become an adolescent from childhood overnight. As developmentalists, we define the period of human development known as adolescence as marked by the onset of puberty, which in the United States on average is about 10 years old, and it concludes with the complete functional maturation and integration of the brain's circuitry. So if you have to put numbers on that, which is hard to do, right, as a scientist, we we like to hedge and caveat, but if you look at mounds and mounds and mounds of neuroscience data in the aggregate, we're typically talking about the period between ages 10 and 25, right, as a whole. And so this developmental period can be further demarcated into kind of subcategories. Early adolescence, 10 to 13-ish, right? Middle adolescence, 14 to 16, 17, approximately. Late adolescence is that period between like maybe 18 to 20, 21. Depends on what construct you're studying. It depends on your sample. It depends on your research question. And emerging adulthood or early adulthood is this period between 22, 23, 25-ish, right? So those are generalized subdivisions of this developmental period. But one thing is absolutely clear. There is nothing developmentally relevant about age 18. It is, from a developmental perspective, completely arbitrary. And that is not what I'm here to argue to you today. And I say that to lay the foundation for the developmental science on youth behavior and decision-making in interrogation. When I use the word youth and adolescence when I am talking about developmental constructs, and I use the word juvenile when I am talking about someone's legal status as a minor, because juvenile has no salience from a psychological scientific perspective. And in fact, it is arguably it's negatively emotionally valenced, right? We talk about juvenile is a derogatory term in some contexts, like juvenile behavior or juvenile diabetes. We don't ever use that word that I can think of in a positive way. So developmental scientists resoundingly agree that this spectrum-like approach is a more fulsome and scientifically accurate way of describing this unique period. And it is a unique period, right? So adolescents are not just big kids. They are not just mini adults. So if you go all the way back to sort of from an evolutionary perspective, the human brain, which is the critical piece of infrastructure that changes during this period, evolved to meet the unique needs of this life stage. And developmental scientists are trying really hard to change the narrative around adolescence and to move away from a risk-based approach. And there are many risks and vulnerabilities. In fact, that's what I'm here to talk to you about today. But also to point out the advantages of this period. Adolescents are really good at solving problems and thinking creatively, and they're resilient. And, sensation seeking and a propensity toward novelty is environmentally advantageous, right? Or it was at one point in our evolution as humans. So a key feature that underlies adolescent behavior and decision-making in the interrogation room is the neuroplasticity of the brain. And we don't have time to talk about that here, but essentially, the brain is growing and changing in really noteworthy ways that have important implications for interrogations. So I'm going to talk very, very, very briefly about the limbic system and the cortical system in the human brain. So we call the limbic system the sort of socio-emotional hub of the brain. This is the like grand central station for emotions and sensory cues and novelty and reward, right? So for adolescents whose sociolimbic systems are rapidly changing, intense sensations are really attractive, right? No brainer. You don't need me to tell you that. You don't need a developmental scientist with a PhD to tell you that adolescents are really drawn to novel sensations. But we have massive amounts of really elegant fMRI research to show how this plays out. We know that because of changes and heightened activation in the socio-emotional limbic system, that adolescents are really sensitive to rewards. And that reward sensitivity can outweigh the perceived risks of the situation. So adolescents are good at calculating risks, but they are not good at judging the relative value of risks and rewards, especially immediate rewards, like, for example, the reward of getting out of a stressful situation, of ending a high-stress interrogation, especially one where you are uninformed and unsupported. We also know that delayed gratification is really hard in adolescence, right? Is really hard. The construct is called future orientation. That means an ability to think about the future implications of our present actions or to plan ahead. Adolescents suck at it. And it's not their fault, right? They are works in progress. They are impulsive and they are more likely to take risks. And these are typical features of development. These are not character flaws. They are part and parcel of the human experience. So couple those changes in the socio-emotional limbic system with the cortical system, which we call the cognitive control center of the brain. So growth and maturation of the prefrontal cortex, that orangey area right here, the big lobe that sits right behind your forehead, is quite literally the last part of our brain to develop. And it does not completely finish baking, so to speak, until the mid-20s. And that's really important for police interrogation because the prefrontal cortex has really important jobs. Its job, we call it the CEO of the brain sometimes, right? Because the prefrontal cortex helps us plan ahead. They help us make decisions, especially decisions in stressful or uncertain circumstances. It helps us with critical thinking and with our ability to self-regulate, to control our behavior and our impulses when our environment is driving us to do otherwise, right? That piece of the brain does not finish growing, so to speak, and integrating, right, with the other brain systems until, on average, the mid-20s. And there's, again, some really, really elegant cognitive neuroscience research showing the sort of interconnectivity of these systems and how that process matures over time. And I'm telling you right now, it doesn't stop at age 18, not even close. So now we move from brains to behavior, right? How do those changes in brain function and structure manifest in adolescents' decisions and behavior? Well, impulse control is a big one. Adolescents do not have the tools in their toolbox to control their impulses in the way that fully functional adults do. They have this present orientation, right? This preference for the here and now at the expense of the future and later. Right? The neurological pull of immediacy, immediate rewards, and novel sensations is so much more attractive, right? The dopaminergic pathways of the brain are really sensitive during this developmental period. Partially because of this, adolescents are more sensitive to pressure from peers than both children and adults. The role of peers becomes really, really central and important, and it's a critical part of healthy adolescent development as well, but also contributes to delinquency, right? We know that kids commit crimes in groups. This is part of the reason why, right? Reward sensitivity, right? What can I do to feel better right now? Whether that's substance use, whether that's telling a police officer what they want to hear, whether that's telling your parents what they want to hear. Youth are attuned to the social cues that generate reward at a neurotransmitter level in their developing brains, right? Same thing goes for sensation seeking. When I was looking for a photo for this slide, I caught myself, like, I was about to Google teen. I was like, wait a minute, this is a publicly funded university computer. I should be careful here, but I needed an image. So these are the ways that the adolescent brain manifest in behaviors that can be both advantageous but also create incredible vulnerabilities. And by the way, that's just normative adolescent development. Normative is the scientific nerd word for typical, average, right? Absent any developmental delays or extenuating environmental circumstances. Think about what we know about rates of trauma among justice system involved youth. Think about what we know about the rates of mental illness among people of all ages who who interact with the justice system. Think about the rates of abuse and neglect among children who are justice involved. the widespread effects of poverty and socioeconomic disadvantage, even things like literacy rates. Like research shows that kids who have criminal records or are otherwise involved in either social services or the legal system have lower rates of literacy than the sort of average population. So all of these things are aggravating factors that interfere with youth's ability to make good, rational decisions, right, in their own best interest, whatever that may be, when they are questioned by police. So what does that look like in the interrogation room, right? Police interrogations are very seldom low stakes or emotionally neutral situations, right? That lack of future orientation manifests as, how can I get out of this situation right now, right? What can I do or say to make this end, to make this stop, and somebody will sort it out later? A lawyer, my parent, a teacher, right? The preference for the here and now is palpable for youth because of their developmental status, coupled with their limited legal knowledge. So they don't, by and large, understand what attorneys do or how they operate in the interrogation room. They don't understand that police are legally allowed to lie. They are entering into that room with a very different set of goals and tools than the adult interrogator. This also relates to an idea that we've studied extensively in the interrogation science around suggestibility and compliance. So interrogative suggestibility means the extent to which a person being questioned about a crime comes to accept messages that are communicated to them, and they conform their behavior or their answers to those messages, right? So whether that's yielding to leading questions, which of course police are allowed to do and trained to do, or actually shifting their answers in response to negative feedback, right? In either explicit or implicit communication that what you're telling me is not what I want to hear. Youth are more likely to shift their answers in response to negative feedback compared to adults. Suggestibility is separate, conceptually separate and distinct from, but related to, this idea of compliance. So compliance is just going along with the requests from others for some kind of instrumental gain, like to get out of the room, to go home. We hear that time and time and time and time and time again in documented false confession cases. I just wanted to go home. In American society, we socialize youth to comply with authority figures all the time. Parents, teachers, right? It's no surprise to you that they are supposed to obey adults, and that extends to the interrogation room as well, right? Doing or saying what they think the police officer wants from them if it means they can go home. Think about the implications for Miranda waivers there, right? A lot of times in the cases that we work, we see good faith efforts from detectives to say, do you understand the rights that I've just shared with you? And the kid will nod, or they'll say yes, or yes, sir. Those behavioral indications of comprehension are not necessarily correlated with actual comprehension. They could be manifestations of compliance with authority figures, because kids aren't dumb and they know what they are supposed to say. They know how they are supposed to respond in social situations. Think about the implications for voluntariness, right? If a youth has a biological and social proclivity to comply with authority figures, what does that mean for a true confession voluntariness, right? And for me, it comes down to this issue of imbalance of power. You have an interviewer who is an adult, a legal authority figure who is well-versed not only in the law, but what information they need to elicit to make that confession stand up in court. They control the entire interaction, where the interaction occurs, how long it lasts, what questions are asked. The juvenile suspect is a minor. They are in a defensive position. They often have limited legal knowledge, and they know they are in trouble, or they feel that way. So there's this tremendous imbalance of power that happens in the interrogation room that compromises youth's ability to make decisions, rational decisions, for which they are entitled from a due process perspective. So it's no surprise that we see that young people are overrepresented in cases of documented false confessions. And Saul talked about this earlier. We know this from data from multiple sources, and we see it in research too. So whether it's self-report studies of youth who were interrogated and report their false confession experiences, whether it's lab studies, experimental studies in the lab, where we can systematically expose youth to false evidence and see how they react, and Allison has done some pioneering work in that area. Whether we're talking about hypothetical vignettes, asking people what they would do in certain situations, we see these youthful vulnerabilities, right, and compliance-related legal decisions, and we even know from work with police officers that law enforcement are trained to use the same techniques with kids, with adolescents, that they use with adults, and they report actually using those same techniques, including both sort of empirically appropriate and coercive techniques with juvenile suspects at the same rates that they do with adult suspects. So it is happening in the interrogation room. And before you say, well, that's why we have parents, no, 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 no. That is a diatribe for another day. I really wish I had like 3 hours to talk to you about parents, but we see legislators, and I'm a parent, so I can say that, but I don't have a teenager yet. These laws that Saul were referring to, many of them are prohibiting deception from adolescent suspects, and that's a movement in the right direction. But before those came along, we see laws that are requiring parental waiver, parental involvement in waiver decisions. And the idea, right, is that parents can compensate for youth's deficits. They can ensure that those waivers are knowing and intelligent. If police do impart coercion, they can buffer against that coercion. And I'm here to tell you right now that based on empirical evidence, that is not a defensible assumption. Parents bring their own baggage into the interrogation room. They bring their own compromised and challenging circumstances and their own vulnerabilities into the interrogation room. So here's an article that I wrote about it that you can peruse at your leisure if you are interested in the parental issue. But to conclude, what we know, right, is from research from a variety of sources that youth have documented vulnerabilities in the interrogation room that are driven by their developmental status, then it is exhibited and supported by wide-ranging research. What's important to remember is that adolescence, this vulnerability, is a period of transient developmental immaturity. They will outgrow it, most of them. And so we have to recognize their developmental stage and how the system might be penalizing them for what is a normal part of human development that we all experience. So there are really, really serious implications, lifelong implications for adolescents who falsely confess, and we know this happens with some regularity. And I'll end with what we can do about it, right? So developmentally informed training is a big piece of that, and police officers tell us that they want more developmentally informed training. More broadly than that, we need a culture shift, right, toward non-accusatory, evidence-based interviewing, investigative interviewing approaches. And right now, given the adversarial system that we have, we need legal representation for youth to ensure that their constitutional rights are observed in that context. So we will be discussing all of these things in the review paper, which we hope is very, very helpful to prosecutors, to defense counsel, to judges, to law enforcement officers, as we sort of try to use science to kind of drive a path forward. Thank you.
All right, thank you. I'm Kyle Scherr. I'm a professor of psychology at Central Michigan University. Thank you for inviting me to be here today. How much time should I leave you? Because I know you want 0 minutes, but I'm going to leave you a lot of time.
I'll tell you like minute 13 or something.
Okay. Yeah. I'm going to kind of further talk about some of the stuff Saul had started with and go into some more detail about how confessions can corrupt other kinds of evidence. And Some of the stuff that I discuss with you might seem a little bit unbelievable, but I think it's important to understand to really drive the point home in some of the research. So I'll talk about research. I'll also give, I think, a few case examples of supporting the research. So we know now from a basic body of literature, but also applied to the legal system and outcomes, that false confessions can corrupt other kinds of evidence. Even evidence like the interpretation of DNA, which might seem a little bit unbelievable, but we'll get there and discuss it. So I'll start out talking about the psychological basis a little bit. Saul went over some of that with you. I'll then talk about the corruptive influence on law enforcement, the corruptive influence on forensic analysts, and end with the corruptive influence on lay witnesses. So what is the psychological basis? How does this happen, and why does this happen? How can false confessions be this powerful to kind of corrupt and alter and modify other kinds of evidence and the investigation? One of the reasons is the general fundamental attribution error, a very powerful attribution heuristic. And the idea is that humans have a really strong tendency for us to attribute behavior to a dispositional cause, to a trait, rather than to a situational cause. So I'll give an example. I drive by and I see Allison just stomping at the bus stop, just stomping on the ground, being really aggressive, really hostile. And I look at her, and my immediate attribution is that Allison's a mean person. She's aggressive, she's hostile, but I don't take into consideration factors that may have led her to do that, situational factors, like the fact that she was trying to get a bee out of her hat and didn't want to be stung, right? And we don't consider these situational factors. And the same thing goes with a confession. We hear that someone had confessed, we immediately attribute guilt to that person. And we fail to appreciate all the situational factors that could have led to that confession. The coercion, the person's desire to get out of the room, the person's promise that they were told that they could go home and see their parents. But we instead rely on these dispositional attributions. The second thing, and Saul talked about this a little bit, is that we have this intuitive trust in statements that go against our self-interest. We're very skeptical about statements that are made in a glowing fashion. We rightly are skeptical of those. If I told you I was the smartest person in the room, you'd be rightly skeptical of that, and you should be. But if I told you something that goes against my self-interest, you wouldn't approach that with the same level of skepticism. And the same thing goes with confessions. Why would anyone falsely confess? You don't apply the same level of scrutiny to that because it doesn't make sense that someone would do something that goes so much against their self-interest. Saul also talked about this a little bit, so I'll try and go quick. We have a really difficult time distinguishing between truth and deception, between guilt and innocence, which are different. But in general, even people who are trained and who are experts, they're really no better than chance. Their ability to say someone was telling the truth or someone was lying to them is about as good as a flip of a coin. The problem is, as Saul walked you through, false confessions are rich, they're vivid, they're these really detailed narratives that make it almost impossible to distinguish them from a genuine and true confession. And the last one, and probably one of the more important ones, I would argue, is that there's a forensic confirmation bias, the general confirmation bias applied to a forensic setting. Once a confession is obtained, instead of scrutinizing that and looking for evidence that disconfirms the validity of the confession, we look for evidence that supports that confession. And in many ways, as I'll walk you through, we actually create a body of evidence to do just that. And when we come across something that goes against that goes against that expectation of guilt, we disregard it. Or in some instances, we interpret it in a way that is consistent with our expectation of the person's guilt. To start into a nice illustration of just the corruptive influence of confessions, I'll open with a study by Saul and his colleagues. They looked at exonerations in the Innocence Project database. And they wanted to look at a couple things. The first thing was whether there were more factors associated with false confession cases than there were other factors associated with the other factors. And so if you have a case that involves a false confession, are there other factors as well that are associated with that case? And that's exactly what you see. So if you have a DNA exoneration that involves a false confession, you see that 78% of them contain additional factors. 22% of them don't. But if you look at DNA exonerations that do not include a false confession, you see that less than half of them contain additional errors. Right? So this is good evidence showing the ability for confessions to corrupt it. But you're all smart people, and you might be thinking, well, do they come first? Do false confessions come first? Because in order to corrupt, they would have to be there present first. And so they also looked at this. And when you break down the order in which confessions come, they come first in more cases. They come first in a higher percentage of cases than the other factors do. So false confessions in the IP cases come first 65% of the time, which gives you evidence that they're corrupting all of those additional factors that are also included in those cases. So we'll start with what effect do confessions have on law enforcement. Again, this is like Saul was saying and Hayley was saying, this is tough to do in 15 minutes, so I'm going very quick. I'm happy to talk about any of these issues in a little more detail. Even manuals like the READ technique, and it's weird to use best practice in the READ manual in the same sentence, but I'm going to do it. The READ manual even says that best practice is to corroborate a confession, that once a confession is given, it's not the end of the investigation. In fact, it's really the start of it. And I think they have even language even in their manual that says a good confession will lead to so much additional evidence that you won't even need the confession at trial, right? And maybe that's true. The problem is that a lot of times, once the confession is obtained, things stop. The investigation stops. And if it doesn't stop, it's altered in some really meaningful and in disadvantageous ways. And so we see from the literature and also from cases that you see a premature termination of the investigation. We got the confession, we're all good, let's move to trial, let's get the guilty plea, we can stop here, we don't need to do anything else. And what's equally frustrating and problematic is that they fail to follow up. It's not even the case that they're reinterpreting evidence here. They're just failing to corroborate. They're failing to go on further with the investigation to follow leads that could show this person is innocent, that could be exculpating evidence. I'll give you one case, the case of Kevin Knox. Maybe some of you know about this case, maybe some of you don't. It's not an exoneration because fortunately the case was dropped before it went to trial. Kevin Knox's 3-year-old daughter, 5-year-old daughter was 4-year-old daughter, 3, 4, or 5, between 3 and 5. His daughter was brutally murdered in Illinois. The case was cold for a little bit, but both Kevin and his wife were under a lot of suspicion. And finally, they brought Kevin in to be interrogated. And this was a lengthy overnight interrogation. And after a lengthy interrogation, he confesses. And one of the reasons, there were many, but one of the primary reasons he confessed was that the interrogator told him, we have DNA being tested right now. If you're really innocent, the DNA will show you that you're innocent, and you can still confess right now, everything will be fine tomorrow. Kevin confesses, investigator leaves the room, says, no need to test that DNA. We got our guy, case closed. What's also interesting about the case is that by the body, where the body was found in the ravine, was a shoe of the actual perpetrator with the perpetrator's name on the shoe. But the confession was obtained, and it didn't matter. He languished in prison for 9 months, or in jail for 9 months awaiting trial, and it wasn't until his defense team finally got a hold of the DNA to have it tested that implicated the actual perpetrator whose shoe was right near where the victim was found. It's an interesting case. If any of you want to look more into it, there's some interviews with his family and him about the whole process. What about the effect on forensic analysts? I'm going to go through this rather quickly. We could talk about numerous studies, fingerprint, we could talk about arson, we could talk about a lot of forensic science domains, which is a misnomer. But we'll talk about DNA. And the study I'm going to show you is from a case in Georgia in which there was a confession associated with the case. And ETL Dror and his colleague, they were a little suspicious of the confession. And so what they did is they got the actual DNA from the case. And in the case, all of the forensic examiners said the DNA could not exclude the actual suspect. So 100% of them were essentially saying that this DNA fits with the associated confession. What ETL did with his colleague is sent it to 17 FBI analysts without the contextual information about the confession. We're just sending this to you. Please analyze it, compare it to what we found at the scene of the crime. Okay. Here's what you find when you don't include the information about the confession. Only one of them, 6%, one of the 17 said could not exclude. I think 3 of them said it was inconclusive. The remaining 70% said excludes. There is no match between the associated confessor and this DNA. Right? And this is telling. I talk about the DNA one because I think it's the most powerful. If confessions can modify and alter the interpretation of DNA evidence, imagine what it can do to other kinds of forensic sciences, and we know it has an equally potent effect on those domains as well. What about the effect on witnesses? And I think here's where I'll end, so I'll give you enough time, Allison. We know that they can corrupt alibi witness accounts. I'll give you one lab study as an example. I'll give you a case study as well. In this study, participants came in with a Confederate, and they engaged in a variety of things. They were physically present together. And then participants left, and they were told, or the Confederate left, and participants were told that the actual person they participated with was being accused of wrongdoing. And they wanted essentially to know their account of the story. Do you account and support this person's alibi for their behavior during the study? When participants are told that the person who is being accused denied all involvement and has continued to deny all involvement, 95% of them support the alibi, which they should. This person did nothing wrong. But look what happens, and this is a very quick turnaround. This isn't like the real world where alibis need to be supported a week later, or 2 weeks later, or a month later, where memory can kind of diminish and take over. When the participants were told that the accused actually admitted guilt and admitted to engaging in that wrongdoing, now over half of them retract their support of the alibi. And this is quick, right? Saul, this is one of your studies. This was like within 50 minutes.
And they're in the same room with that person while this theft was taking place.
Yeah,
and
physically there. Yeah. And so this is really meaningful. In the moment, it's a confession is able to change the alibi account or people's confidence and willingness to support that alibi. Imagine what it can do when you have additional police pressure and across time. One case I'll highlight is the John Kogut case. I won't go into detail about the case, but Kogut was, again, interrogated overnight, lengthy interrogation, eventually confessed, implicated 2 other people. He had, I don't know how many people know this, but he had an airtight alibi, a really airtight alibi. In fact, the 2 or 3 alibi witnesses came forward, and they were steadfast. They were confident in supporting his alibi. He confesses. The police go back to those alibi witnesses, and all of a sudden the alibi witnesses are no longer willing to be alibi witnesses for him at trial. And he was eventually convicted. Effect on witnesses, I'll give you one other account and study. Confessions can also influence eyewitness memory and confidence, which is really, really important because a lot of crimes are solved and based primarily on eyewitness accounts, or the process often starts with an eyewitness account. I'll give you another study, this one done by Lisa Hassel and Saul as well. It was a two-part study where people watched a crime take place, and then they had to pick out a perpetrator from a lineup. And they were told the perpetrator may or may not be in the lineup, and the perpetrator actually was not in the lineup. So the first couple sets of results I'm going to give you were for people who actually made an identification, which would have been a wrong identification because the perpetrator wasn't in there. And so this first graph are people who made an identification at the first phase. They were then brought in subsequently for a second phase, and they were asked to do the identification again and to give confidence again, and they were told a variety of things during the second phase. Some participants were told the person you identified actually confessed. When people were told this, who made an identification in the first phase, they became more confident. This is what you would expect. This is reasonable to expect. When participants were told everyone in that lineup denied, people got a little less confident. Again, what you would expect. When people were told the person you identified denied, they became a little less confident again. But when they were told someone else confessed, they became significantly less confident. Now, I'll show you the same group. Again, these are people who made an identification at the first phase. These are the percent on the y-axis of people who actually changed their identification. So they shifted from phase 1 to phase 2. When people were told the person they identified confessed, like 2% change. What the hell? Who are these people? Why are you changing? The person you identified confessed. Oh no, I think it's someone else. I have no idea what's going on there. What about people who were told everyone denied? A lot of those folks changed. What about the people who were told the person you identified denied? About 28% of people changed. What about when they're told someone else confessed? Right? Over 60 people confessed. So this provides a little bit of initial evidence that confessions really change memory. It changes your memory and your confidence for the eyewitnesses. But it's the next two graphs that I think are more intriguing to me. These are the people who correctly rejected the lineup at phase 1. These are the people who made a really good decision initially. What happens to them when they're brought back in the lab and told something different? This first graph is for their change in confidence again. What about the folks who correctly rejected the lineup at phase 1, but were subsequently told everyone denied? Right? They got more confident, again, as it should be and as you would expect. What about when they were told an unspecified other confessed? Right? Oh, they're getting less confident in their initial judgment, and when they're told a specified other confessed, they're also getting less confident. Now again, how many of these folks changed identifications? Again, this is going from a good decision, a good identification, to a wrong and a mistaken identification. When everyone was told all denials, no one changes. This makes sense. This is good. What about when they're told an unspecified other confessed? Right? 45% of them change. You go from correctly rejecting the lineup to making a mistaken eyewitness identification. And the same thing happens when a specified other confesses. 50%, half of this group, change from someone to an innocent person, from making no identification to an innocent person. So I'll end with kind of the take-home and the summary statement. This is a critical juncture in the investigative process. This is a point at which there's a great opportunity to kind of correct the process, to undo what had happened in the interrogation room. But what we see instead is that the disadvantages accumulate here. And what happens as a consequence of that confession is that a body of evidence is molded, is built to support that confession, making it even less likely that the process will be corrected, making it even less likely that the innocent person will not be convicted or will be exonerated. Right? All right, thank you.
Okay. I want to leave time for questions, so I am going to probably skip a lot of slides and go pretty fast. But, oh, sorry, I like to walk around. So the reason I wanted Kyle to go before me is because another way that confessions corrupt subsequent processes in the criminal justice system, criminal legal system, is that they lead to pleas. And when I say that's corruptive, I mean that when somebody pleads guilty, as all of you know, people are giving up all of their due process, not all, but many of their due process rights, all of the safeguards that they're getting at trial, their right to prove guilt beyond a reasonable doubt, the right to maintain their innocence, and so. In the interrogation scientific review paper, version 2, my job was to talk about the effects of confessions on guilty pleas. I covered these 3 topics. I'm not going to go over all of them. I'm going to really try and focus on the effects of confessions on plea decisions. I'll say a little bit. I think we all know that guilty pleas are the modus vivendi for convicting defendants in the U.S., and we see this in many other nations. In the past 25 years, more and more nations are adopting guilty pleas, and what we're also seeing is that when they adopt guilty pleas, very rapidly, 80% or more of their cases are resolved by guilty pleas. And of course, I think all of you know in this room that 97% of convictions in the United States are resolved through guilty pleas. In some counties, we see cases, felony cases that are start from arrest, not from the end point of conviction. 100% going forward are result in a guilty plea. We talk about in the white paper how many of these same problems that plague our system of pleas today were talked about in the first Presidential Commission on Law and Justice report 55 years ago. Surely safe to assume that many mistakes are made. They're citing many of the same problems that really plague our system of pleas today. You know, and our Al Schuler, who's one of the leading experts on guilty pleas, has a paper where he talks about how our plea system is a nearly perfect system for convicting the innocent. And of course, if we look at the National Registry of Exonerations, we see about 24% of the wrongful convictions that we know about are from guilty pleas. I'm going to skip this. I mean, we talk about the innocence problem. We talk about in relation to pleas, we talk about excessive plea discounts, and we talk about problems with discovery. I'm just going to skip to this slide. This is one of my doctoral students who just defended her dissertation, where it was a laboratory plea negotiation study where she assigned people to be either guilty or innocent of the crime. And another manipulation was that they either received a plea discount of 80 to 90% based on the sentence differential between what they received as the plea offer versus what they could get if they were convicted at trial, and that's what I mean by the plea discount. So it was an excessively high discount of 80 to 90% versus a 22 to 32% discount. And you can see here that when the person is innocent and in that excessively high discount condition, they're more than like 6 times more likely than those in the lower discount case condition to plead guilty. And I'll also mention that if I go back a slide, this was, I just plotted some plea discount rates using actual plea data in Virginia. And it is not uncommon at all for plea discounts to be around 90%, 95%. So I know that when I go shopping and something's 95% off, I'm going to buy it, even if I don't need it. Discovery, I don't want to go too much into, but prosecutors are not required to turn over exculpatory impeachment evidence in the context of pleas. Of course, they have the discretion to do so, and I'd like to think that many do so. This is a question that I think will be coming up more and more. There has been some of the Fifth Circuit case where they did extend this to Brady material. The Supreme Court had in front of them a case that they chose not to hear, but like I said, I think it'll come up again. And we see this play out in cases. This is, Saul also had Joe Buffy. Joe Buffy gave a false confession, was during the interrogation process. He was offered a time-limited plea deal. At the time, the prosecution had exculpatory DNA evidence that he did not turn over to Joe or Joe's attorney, and Joe pled guilty on the advice of his defense attorney. He spent 14 years in prison before the case was overturned. Because of Joe's case, West Virginia now requires that Brady material be turned over in the course of pleas. But again, thinking about that 97% of our convictions are through pleas, and there's not an automatic right to at least exculpatory impeachment evidence. Skip that. So what I really want to focus on is this effects of confessions on plea decisions. And I'll say that this is a brand new area for SRP number 2. This was not something that was included in the first interrogation confession white paper, but there's been a tremendous amount of research in the past 13 years about the science of pleading guilty and the effects of plea bargains on decision making. So we know that confessions, they've been called the king of evidence, the queen of evidence. The Chinese have a saying that convictions begin with confessions. Because they are so powerful, and Saul went over this another way, to that safeguard process. People give false confessions. We think that we might be able to intervene before it turns into a conviction, but people can't recognize that in juries, and it's judges as well. There's been research on judges. They also suffer from those same things. But the predominant theory of plea decision-making is what's called bargaining in the shadow of the trial, and I'm sure many of you have heard about this theory before. And given that confessions are so powerful at trial, it makes sense that they induce guilty pleas. So if I'm a defendant, I'm a defense attorney, I'm a prosecutor, I'm going to offer a plea bargain, right? I know, or if I'm a defendant, I'm going to accept that plea deal because I know that my chances of being convicted at trial, where I might receive that trial penalty, the trial plea discount versus trial penalty, two sides of the same coin, they induce pleas. And I call this the confession to plea pipeline. And there's a lot of actual court data on this. We can look at cases where they have confessions and evidence, and we see increased likelihood of pleading guilty. We see this in defense attorneys responding to hypothetical cases. Sorry, I'm getting older and my eyesight's so bad, so I can't read my slides over there. I hope people can still hear me, but yeah. So in one study, we found that when there was a confession in evidence, over 1,500 defense attorneys, judges, prosecutors responded. We see that plea advisements, plea offers, they go up about 10 percentage points when there's a confession and evidence. One of Johanna's study with Saul did a study where, again, with actual defense attorneys, they were given a condition where there was no confession. They recommended pleas 3% of the time. They looked at whether the judge had ruled the confession as inadmissible and therefore not be able to be used at trial. It went up a little bit, but at 10%. However, when there was an admissible confession in evidence, it went all the way up to 39%. So we can see here the effects of this bargaining in the shadow of the trial and forecasting the likelihood of a trial conviction. And when there's a confession and evidence, we see it more likely. We also see this with mock defendants in a avatar vignette situation where they're given either confession evidence against them or eyewitness evidence against them. And in those compared conditions, we see that more defendants are pleading guilty. And this is the same pattern for true and false guilty plea cases. I have a new study coming out using a National Registry of Exoneration cases. We did a multivariate regression analysis where we're looking at 10 different factors, I think, and we see that false confessions, they predict false guilty pleas at a rate of 4 times. We see this in Innocence Project cases as well. So take-home messages, guilty pleas are admissions of guilt and subject to the same situational and dispositional risk factors that induce confessions in the interrogation context. We talked about some of the youth and the other factors. These large on-scale plea discounts, when we talk about reform in terms of guilty pleas, one of the things that always comes up is making caps on discounts and not allowing these large plea discounts. Reforming discovery laws. There are a lot of states. My home state of Virginia recently reformed their discovery law. The word trial appears 17 times. The word plea does not appear 1 time. So even though they did some great reforms in terms of discovery and sharing information between prosecutors and defense attorney or defense, we don't really see that in the pleas all the time. So I think I'll just end there. And I know we have a couple of questions. Okay. I'm going to try and answer this one first, but then I would like Saul to jump in. But I think it's a really good question because the person said, what is SRP2? And I want to explain that this scientific review paper, a little bit about the process. It is a scientific consensus paper. We are in the draft. Again, this is the first time that we're presenting to any audience. It is a beast. I keep telling Saul, it's like almost 200 pages right now. But as we go through this process, it is going to be vetted and approved by the American Psychology Law Society, which is a division of the American Psychological Association. And it does not represent merely the opinions of the 7 authors. It really is a consensus paper on the state of the science of interrogations and confessions. And in the end of the day, it will represent the society as a whole. And so, all 4 of us provide expert testimony in these disputed confession cases. And I will say that it irks me to no end when I have to deal with arguments about general consensus. So whether you are in a Frye state or a Daubert state, you know, this idea of general consensus, it exists. We have the first 2010 paper. We have 10 amicus briefs from the American Psychological Association. To me, that is no longer a question of whether there is general consensus in the scientific community about the state of the science of interrogations and confessions. I don't know if you had anything you wanted to add about what is the SRP. So, scientific review paper. I'm sorry. Okay. I took your question to the next level. Did you want to? Yeah.
It is a highly vetted, the process is quite aggravating, to be honest.
Yeah.
We will be required to present this paper ahead of time at the American Psychological Association, and then we'll be presenting it at the American Psychology Law Society Association meeting. And then it gets posted on the APLS webpage where it is open for comment and criticism and feedback, which we then incorporate into a manuscript, which then gets submitted for peer review to the journal, to the Law and Human Behavior, which is the APLS journal. So it's an extended process that takes about 2 years from start to finish.
And y'all going to call it the white paper 2?
Scientific Review Paper 2.0. Yes, SRP 2.0. Yes.
Okay, how do you account for the detailed nature of a confession regarding actual facts of the crime induced by the police? So, yeah, I think that maybe goes to kind of this idea of contamination, and the police are aware of certain facts of the case. And when as Saul was talking about, when suspects when it appears that suspects are providing these details that only the true perpetrator would know, they're really coming from external sources, oftentimes the police. There have been many cases like the Central Park jogger case, the exonerated 5, where they take them on outings to the crime scene. That's going to contaminate people's version and make it look like that they're the true perpetrators, and then that they know things that only the true perpetrators would know. I think this is what this question is getting at.
Can I just?
Yeah, of course. Yeah.
It's such an important question because it's the reason people believe false confessions. And what they don't realize is a confession may provide details that are perfectly precise and vivid and accurate about the crime scene and not in the public domain, but they were always known to the police who did the interrogations. And so in evaluating, when I give talks to prosecutors' offices, I say, here's what you're looking for. First, are there details? If the details are present, are they accurate or inaccurate or not verifiable? If there are accurate details, next question is the source attribution question. Were those details known to the police who conducted the interrogation? And if the answer is yes, and if the suspect can provide no information about the crime that the police didn't already know, or lead the police to evidence they didn't already have, then I'm not saying that person's innocent, but then there is no corroboration based on the confession of guilt. And those are the criteria to be used, which is why it's so important to have video recordings of the entire process from start to finish without a minute missing, so that you can see the source of that information.
I'll just add one thought there as well. I mean, we I think are most concerned about contamination that comes from police during the course of the interrogation, because that's something that can be controlled. That's something that can be prevented. But contamination can also come from other sources. So community gossip, or, hearing about something on the news, or a co-defendant's testimony. And those are a bit harder to pin down even if you do have a video recording, which is why it is so important that the confession generate new information of value to police, like information that they didn't already have, because we have to be mindful of the possibility of contamination from a multitude of sources.
And just let me add to this. I know it sounds like a high bar, but that high bar enables you to know good confessions when you see them. So, for example, if you're familiar with the famous Kitty Genovese murder from 1964 in Queens, New York, 28 witnesses watched and nobody called the police. The guy who ultimately was convicted of killing Kitty Genovese, he came in and he confessed. Well, how do we know that's a good confession? Well, for starters, he said that he took belongings of hers, including her purse, and that he went through them and then dumped them outside his workplace in Mount Vernon, New York. The police go to the workplace, and sure enough, they're right where he said he dumped them. Or he gave another confession to another crime where he said, I shot the victim 6 times. However, the medical examiner had concluded the victim was stabbed. They exhumed the body, went back in, they found the bullets. He had information for police they didn't already know that turned out to be true. That's how you know you've got a good confession. Short of that, there should be, again, an open inquiry and not a closed mind.
Yeah.
Thank you very much.